Okay, we are live on YouTube. And now I will let us all in. All right, ready? Here we go.
Yep, we're starting.
Good evening. If you're just joining us, we're just open the doors. It'll take a couple of minutes to let everybody in, but everybody welcome. This is the Renters Alliance Renter Town Hall. Good evening. This is the Renters Alliance Renter Town Hall. We're just waiting for everybody to come in the door. Welcome. 'We're just getting started, just letting people in, take a couple of minutes. Welcome to those of you who just come in. Takes a couple of minutes on Zoom to let folks in. Thank you for all of you for coming on such a beautiful day. It's hard for me to be here. I can imagine how hard it is for you. We'll give it another minute or so. You're just joining us. This is the Renters Alliance Renter Town Hall. We're just letting people in the door. We'll give it another minute. Thirty seconds. Okay, let's get started. Good evening, everyone. My name is Matt Losack. I'm the co-founder and executive director of the Montgomery County Renters Alliance. We have a terrific panel with us again tonight for our Renter Town Hall. Let me quickly introduce the folks we have. I've got our staff, David Mullins and Pat Beckham and Malek Demir, and the vice chair of the Renters Alliance board, Chris Perry. And we have some expert panelists tonight. We've got with us Audrey Lynn Martin, a staff attorney with the Homeless Persons Representation Project. And we have Rosie McCray Moody, who appears to be getting electrocuted in her office. Rosie McCray Moody is the recent retired manager of the Office of Landlord and Tenant Affairs and is filling in for Nicole Katravanos, who could not make it tonight because of one of her children has caught a fever. So when Rosie returns for her time, she'll be on and can answer questions based on her long experience and expertise on landlord-tenant affairs. If you have any questions or concerns, we ask that you put them in the chat. Our staff will be monitoring those questions and concerns, and we will try to get all of them addressed before the end of the Renter Town Hall. We are recording and we will post this. It is being posted simultaneously on YouTube. Let me just say some opening remarks about where we are. The rent stabilization bill expired May 15th. County Executive Mark Elrich proposed another rent stabilization bill that if it had been enacted, it would have taken effect in July and would have covered any increases in rent during the 90 days after the May 15th expiration of the previous bill. Unfortunately, the County Council declined to take up that bill and vote on it. They had a brief hearing, but they did not take any action on it. We were told that that bill, which would have capped rents at 4.4%, will be considered this month. But so far, council's communications on that issue have been somewhat vague. The latest report from a story in the DCist said that County Council President Gabe Albornoz was going to send the bill to the Planning, Housing, and Economic Development Committee to consider what kind of options there might be. We are obviously deeply concerned about this and stand with our allies in urging that there be some kind of rent stabilization. The Renters Alliance takes a very reasonable, we believe, point of view. We believe that a landlord deserves to make a reasonable return on his or her investment. We understand that they must keep up with expenses, but we do not support any way, shape, or form rent gouging. We are seeing double-digit rent increases in Montgomery County, and Lord knows it's happening in other places around the state. We have a very high demand region, which means that the market allows for these double-digit rent increases, but the market does not protect the existing renters. And so people who are seeing their rents go up by 10, 20, 30% or more are looking at where they're going to move, and they're going to be priced out of their homes. People who are in debt already because of COVID or because of the economy are going to be forced further into debt and possibly have to lose their homes. The Renters Alliance position is that what we are seeing, excuse me, is the forced migration of working families, low-income families, and people on fixed incomes. There are costs to this kind of housing instability, an instability that's going to affect thousands, if not tens of thousands. Keep in mind that nearly 40% of Montgomery County residents live in rental housing. That's up from 23% in 2007. So this is becoming a way that a large percentage of our residents live permanently. And yet their housing has become extremely unstable. What are the costs? Well, obviously the cost to an individual family that has to move, the cost of actually moving, the cost of perhaps becoming homeless, the cost of the anxiety and depression and health issues that come with not knowing where you're going to move to. These are serious issues. The costs of children having to move from school to school and the impacts on their academic achievement, the costs to seniors who invest decades in their homes only to find that in the twilight years of their lives, that their homes have now become suddenly unstable and they don't know where they're going to move to next, causing health problems and severe anxiety and other issues. So it is quite an issue, a public policy issue that we think deserves emergency action by the council.
I have to evacuate the building, sorry.
Well, Rosie, see if you can join us in another way, all right? Come back to us later. Don't stay in the building if there's a good reason to leave. As we tell all of the tenants when the fire alarm goes off, get out of the building. So do it. But see if you can take a laptop with you and join us later, okay? So anyway, this is what we're seeing. We are also seeing the courts had been closed in the spring, but they reopened, I believe, in April, and that the evictions had been low because of the state and federal eviction orders that prevented landlords from evicting if a tenant could show that they were behind in their rent because of COVID. Those protections have lifted. and the courts have reopened, and they have caught up to a backlog for the most part and are now moving full speed ahead. This morning, myself and my colleague, David Mullins, went to housing court where there were over 500 people in the morning going through a single court and another 500 in the afternoon. Over 1,000 people, most of them low-income people and families who are significantly behind in their rent and had very little defense against potentially being evicted. This is a tremendous problem, much bigger than most people want to acknowledge. And we're going to have to advocate for it. And we hope that all of you listening understand the gravity of this situation. And also keep in mind, Montgomery County is one of the wealthiest counties in the United States. We can only extrapolate that if it's this bad here, it is much worse in other parts of our state and our country. So it is a housing crisis. And the Renters Alliance is doing what it can to assist tenants with these issues, to guide them to resources, to explain their rights to them, and get them in touch with important organizations that are doing really important work for us and for tenants. And so that brings me to our first guest, who is an expert in housing law and is a staff attorney with the Homeless Persons Representation Project, which has newly been involved in doing direct court work during housing court days in Montgomery County. So it's my pleasure to introduce the esteemed Audrey Lynn Martin. Audrey.
Thank you so much, Matt. So first of all, I'd like to thank you for having me on. It's a pleasure to be here. And I would also like to state before I get into my presentation, echo and co-sign everything Matt has said about the need for rent stabilization in the county. My presentation, you're going to hear a little bit more about the lack of defenses that tenants face when going to rent court, and rent stabilization will help maybe disrupt that cycle because it is an incredibly high volume court, a lot of tenants going through the system, and we need to see some more major changes because this is absolutely an affordable housing crisis. So I would like to co-sign on behalf of HPRP in support of the Montgomery County rent stabilization and all of the organizing efforts around that. And now I can get into telling you who HPRP is, because I'm sure this is maybe a lot of your first time hearing about us. We haven't been operating in Montgomery County very long. I'm going to share my screen briefly to throw up my contact information as well, so people can jot that down. So that way, as you're here through the presentation, if you have questions, you can follow up with me after. So let me go ahead and do that. Okay. How do I present? Well, either way, this is the contact information. That's mainly the slide that I want to show you. I'm not going to make you go through the whole slideshow because, you know, nobody likes to have a PowerPoint read to them. But this is my contact information. Absolutely take this down. The phone number is our office number, so that doesn't read directly to me. But if you are a tenant in Montgomery County and you would like to speak to an attorney about your rental case or get advice or full representation, you can call this number or email me. So I will leave that up for another moment just so people can get that, take a picture on your phone, however you need to get that information. All right. Okay, so I can also begin by explaining just a little bit who HPRP is. So we are the Homeless Persons Representation Project. We were initially a Baltimore-based organization operating primarily in Baltimore City itself, and has been operating there since the 80s. We expanded into Montgomery County maybe 4 or 5 years ago. And with that, we've been growing our program. So we initially started expungement clinics and just civil clinics in the homeless shelters around the county, at Shepherd's Table, Progress Place, Interfaith Works, to name a few. And since COVID and the enormous need for housing representation in the county, we emergency cross-trained all of our Montgomery County attorneys to represent tenants in rent court. And this was when the courts reopened in April 2021. And Montgomery County alone had 15,000 tenant cases, rent court cases piled up when the courts reopened that April, and different jurisdictions handled it differently. And Montgomery County chose to do what we called a rocket docket, just a rapid fire, 4 days a week in court, I believe 3 courtrooms running simultaneously, and they needed a lot of manpower. And there simply was not the representation to do that. There are very few attorneys who are willing to take tenant failure to pay rent cases because private attorneys have to be paid. And if they're struggling to pay rent, they're likely going to struggle to pay an attorney. Luckily, Maryland has passed right to counsel. So there are now funds available for jurisdictions to provide free legal assistance to tenants in the state of Maryland. Now, this is a very new thing and the counties are rolling it out, but we have that contract in Montgomery County now. So that way, maybe we can prevent the same type of inadequacy of representation that happened when the courts reopened. So we will have a permanent presence in the courts throughout. So that is just one of the services that we provide. We also provide any other civil legal services, general criminal record expungements, veterans benefits, discharge upgrades, those types of things. So if you have any other legal issues, you can also contact us and we can at least get you pointed in the right direction. So that's just a little bit about HPRP in general and our history in Montgomery County. And now I want to get into a little bit of the details of what we're seeing in court, the information I know you want to know. I got a court summons, what do I do? So as Matt said, the failure to pay rent court is a very, very enormous docket. There are 500 cases in the morning and 500 in the afternoon. So there is a 9 a.m. schedule time and a 1:30 schedule time. And you have to be there at that time or preferably a little bit before. Because if your case gets called and you are not there, you will lose. If you are there, it's always best to be there. If you are there, then we can talk about some defenses that you may be able to utilize and things to look for and what to expect. There are essentially 2 buckets of eviction cases that you may get as a tenant. One is failure to pay rent, and the other is kind of everything else. And they're in 2 different courtrooms. So the everything else is tenant holding over, breach of lease, rent escrow, and wrongful detainer. So tenant holding over is if your lease has expired and you have continued to stay at the property, your landlord may file a tenant holding over action to take the property back. And there are defenses to that because landlords do not always follow the guidelines and the very specific rules that the county has. And those are the types of cases that really, really benefit from attorney representation. So I'm going to give a lot of information about failure to pay rent court because it is, the one that 1,000 people are going to every single Wednesday. If you are in that other group, so if you have a breach of lease, tenant holding over, rent escrow, or wrongful detainer, I strongly encourage you, even more so than the failure to pay rent, to seek me out, seek Legal Aid out, Casa de Maryland, any other legal service provider, because those cases have more defenses and are more complex.
Audrey, can I just jump in real quick?
Yes.
Just for all of us who are not esteemed lawyers like yourself. Failure to pay rent is obvious. If you have not paid your rent and you owe rent, then you're going to be in court for failure to pay rent. What is an example of breach of lease? What's an example of wrongful detainer? And is escrow an eviction process?
Escrow is not an eviction process. It's in the
Right, no.
same courtroom. I just list it when I list the 4
Okay.
going down my mental list.
If
So
you give us a layman's review of the other terms, please.
Yes. So tenant holding over is if you had a lease and your lease expired and they're trying to kick you out. Breach of lease is if they say you breached the lease. I mean, it's hard to to define without using the term itself, but they are claiming that you have violated the lease in some way other than rent. So this can even be you didn't pay your utilities because utilities aren't rent. So sometimes we see them bring a breach of lease case for failure to pay utilities or parking, or it could also be conduct based. So if you have had a disruption with another tenant, that's one that we see. If there's been disagreements with you and the landlord, like verbal, if there's been anything like that. I've also seen safety concerns, people, leaving candles, or like saying that they maybe will start a fire in they said, I'm going to start a fire. Even just saying that, they could file a breach of lease. And I see a question in the chat. What if they file a wrongful case with the court? So a wrongful case with the court, it can be wrongful for a lot of different reasons. So it may be that they filed the paperwork wrong. It may be that the facts are just on your side. They said you went into the lobby and threatened to burn the building down, and it was just a different tenant that you just look alike. The facts are just on your side, So it could be a legal wrongful or like a factual wrongful. And either way, both of those are defenses that you would want to raise with the court. So if you think anything has been done wrong in your case, you have to tell the judge when you have your day in court. So do not leave that desk without saying what you think was wrong. So today in court, we saw a lot of tenants in failure to pay rent court who had their yellow papers that lists they haven't paid this much rent for this many months. And there was a monthly rent rate at the top, and it said, they paid this much in rent per month on the first of the month. There was an entire building today in court that filed the wrong monthly rent amount. They had doubled every single tenant in the building. So these tenants were coming out of the courtroom and they said, I don't know why it's higher than I thought it was going to be. And I looked at it and I said, the first one I looked at, it said she paid $8,000 a month. And I said, I know you don't pay $8,000 a month. Where do you live? In Montgomery County? And she said, no, I pay $1,600 a month. So we had to go back in and amend that. And the first question I asked all of these tenants was, well, did you tell the judge? And they said, well, no, I didn't understand. And I totally understand that. It's complicated. It's stressful. But I say this to emphasize that if you think anything is wrong, when you are in front of the judge, you have to tell the judge. Because if you tell me after the fact, it's really hard to go back and change that. So if you think anything is wrong, not right, you really have to advocate for yourself, because the judges aren't always going to ask you if there's anything that you want to say. Sometimes it's 1,000 cases. These cases move quick. So you have to advocate for yourself.
And it's often a good idea to advocate before you even get to court. If you see on that summons that it is inaccurate, first of all, you should let the landlord know and see if they will dismiss. If they refuse to dismiss, then you should contact some organization like HPRP or Legal Aid, or even the clerk's office at the court. In my case, the whole Renters Alliance was started because my landlord tried to evict me for failure to pay rent, and the eviction summons said that I had not paid that month's rent or the next month's rent, and it was sworn out in court on a date long after both checks had already cleared my account. So I have an apology letter from the lawyer and a dismissal. So, you do have to be proactive. It's best not to wait to get to court to deal with this if there's something egregious that you see. But as Audrey points out, if it's wrong, stand up for your defense and seek help from the kind of services that Audrey offers with Homeless Representation Project. Audrey is also a wrongful detainer.
Yes, wrongful detainer is saying that you never had a lease, that you have no right to be there, you never had a right to be there. So the main defense to a wrongful detainer is if you have ever had a lease, if the lease expired, if they canceled your lease, if you had a lease and came back, yeah. Wrongful detainer is typically seen in foreclosures. So a property is foreclosed and the original owner is still remaining in the property, then the buyer files a wrongful detainer against the former owner. So
We're
that's commonly
seeing-
what you see. You don't see those as much. So it's those are kind of rare. So breach of lease and tenant holding over are the two most common ones that you'll see, other than failure to pay rent. And if you get one of those, your form will be green. For one, it'll be a different color. The failure to pay rent is yellow, wrongful detainer, often green, sometimes yellow. But if you get those, contact a lawyer. Those have the biggest impact. It's really hard to give you tips without knowing your facts because each case is different. So I'm going to put the pin in breach of lease and tenant holding over. The takeaway is call a lawyer.
Right.
Call
And let me
me.
just throw out some more common wrongful detainers. I think they're wrongful detainers. Correct me if I'm wrong, but we've seen a lot of people whose spouse or boyfriend or girlfriend either passes away or leaves, and they were the only ones on the lease. And then the person is still in the apartment, but unless can demonstrate that they have also not just have a lease or on a lease, but perhaps they paid rent by check. Does that
Mhm.
also count as a defense?
Yes. So in those cases, I definitely could see that being filed as a wrongful detainer. But I do think that if they were living on in the property with the actual leaseholder, I think there's a case to be made for them having a de facto tenancy. So that's what I would argue. So if that is your case, bring it to me. So that being said, I'm going to put a pin in all of those other things. So if you are being evicted for anything other than not paying rent, call a lawyer. If you get the yellow sheet, it's normally posted on your door and mailed to you. And it's a yellow paper. I may have one. I do not. But it's normally posted on your door. And it has a lot of writing on it. It has a top section that has the court, a bunch of words in the middle, and then that bottom section includes the landlord attorney's contact information. That is important to know because a lot of times landlords either don't know the information or they've already passed it off to their attorney and they're like, I don't know, the lawyer's handling it. And so if you have that lawyer information, that's a second choice if you're not getting anywhere talking to your landlord, getting that information. So look on your yellow sheet towards the bottom, probably like 2/3 of the way down. And that's a second choice to go to get that information. So before court, you can see if the case is going to be dismissed. 1,000 cases are in that courtroom every week. And 1,000 people aren't able to be in that courtroom. A lot of the cases are dismissed ahead of time and your landlord may not tell you. The court definitely will not tell you. So I advise tenants to call ahead of time and ask their landlord's attorney if the case is going forward. I always encourage people to go to court if they can, but recognizing that people have to take off work and people have kids and you have to pick your kids up from the bus stop and you maybe don't have time to sit there from 9 a.m. to 11 or 1:30 to 3. They are very long days. Okay, I am seeing questions come in and I'm gonna defer to you, Matt. I know I've taken a lot of your time.
Not at all. And since Rosie has been taken out by the fire department, you have a lot more time. There are some key questions though, and we can banter back and forth on some of these as well. Again, I saw someone who was saying that how difficult it was to be summoned to court, especially without a good warrant to be there. And I say, in my case, I didn't go to court. As soon as I got that summons, I said, something's up here. This is wrong. And if you believe that you paid your rent, and we ask all tenants, please get a receipt for paying your rent. pay by check or get a receipt. Don't pay and then have the landlord be the entire person who could say whether you paid or not. You need some proof. And if you could show that you paid your rent, you should be able to go to the landlord and say, hey, what's up with this? And if they agree that they've made a mistake, you can demand that they follow through and dismiss this case so you don't have to go. There is a process, and unfortunately, we do have to act on our own behalf. We can't allow these things to roll over us, or just let them go and not go to court. That nothing could be more foolish than that.
And I'm really glad you shared your experience, Matt, because I think that egregious, violation of, I paid these months, or this is not my rent, or this case was already dismissed once before. We see that. These egregious things happen very, very often. And so you have to advocate for yourself. You cannot trust the system to advocate for you. Like, you have to be on top of it, because if you miss your case, it's very, very hard to revive claims.
Millette,
Hey, Audrey.
Pat, or David, what kind of
Yeah.
questions are we seeing in the chat?
Audrey, let me ask you, we get, well, I have had several questions from renters who want to know, once they have been evicted, does that record stay with them? Some of them are not able to get other apartments.
Yes. So currently, as it stands, yes. That record does stay with them. So it is on their rental history, and depending on the way that they filed it, it could potentially go on their credit history. So there are like longer term consequences with that. We have been in talks with trying to figure out how to shield some of these cases, because people are running into those problems, because there was an unprecedented number of people who experienced like housing insecurity for the first time during the pandemic. We're a county that has incredibly high cost burden housing. So people paying more than 33% or 50% of their income on their housing costs. And so the pandemic really opened up those cracks that we already were seeing. So we're working on figuring out how to shield some of these eviction cases, so that way they don't have those long-term consequences on folks' record. But as of now, you can only really shield one case, like one case in general. And so if people who have multiple cases, it's difficult. So that is something on our radar.
Can you take that a couple more steps, to not to make it worse, but it's worse? Not only is it evictions, there are other filings that are also part of the record. Can you explain those other damages? I mean, even judgments against, even if you pay and stay, the judgment against is still a public record, is it not?
Yes. So it's still a public record. And I guess there's positives and negatives. So a lot of the failure to pay rent cases, they don't even put into judiciary case search. So like that online public record system, just because there's so many of them, the clerks didn't want to put them into case search. So the good is that that's how a lot of the landlords were doing these checks before. And so they're not showing up. The bad is if they do their checks through a different, private system that pulls official court records, then it will show up.
And we've seen in Maryland, CoreLogic, which is a company that does this, routinely go in and collect that data, and any landlord who has a subscription to CoreLogic can pull down that data, unfortunately. So, as Audrey points out, we are working to see about reasonable shields so that people are not blackballed from housing. But right now, we're still pretty vulnerable.
Yeah. But yeah, anyone who uses that program definitely can see it and can consider it in whether to rent to a tenant. And so it is one of the problems that we're seeing. I'm going to hop over to the chat. I know I talk about these things really broad and generally. There's just a lot of directions to go. So I definitely appreciate the questions in the chat, and we can have a in-depth discussion about like whatever direction that y'all want to go in, since we have a little more time. And we'll see if Rosie can join us again. But let's see.
So if there's a question that I run into a lot, is if you pay your rent in full before the court case, do you still need to go to court?
Yes, I would
Thank
say
you.
yes, unless you have confirmation from like I would even say landlord attorney. I don't always trust like the property managers. A lot of times people go in the leasing office, and the leasing office will tell them they don't need to go to court. Like I don't necessarily think a lot of them are being malicious. I just don't think all of them know. So if the landlord attorney says you don't have to go to court, I would trust that. I'm not
I
sure.
would ask for something in writing.
That's the
you
other
know,
way.
An email or something that confirms that a conversation took place. And we recommend that, we'll say this a million times more, but you're in a business relationship with your landlord. And if becomes a legal dispute, all the more reason for every part of your relationship to be in writing. Doesn't have to be lengthy, but just some kind of an email that says like a receipt for your rent. We had a conversation on Thursday that you were going to fix my refrigerator, and I'm waiting for you to get up there. You said that the case is dismissed, please confirm.
Yeah, or even
because
text.
it will protect you.
Text is great too,
Sure.
Right, anything in writing.
Right.
Yes, and always get receipts. Like even when you think you don't need them, even when you think you have a good relationship with your landlord, it's always get receipts, pay in a way that you can verify, because I know a lot of landlords lately have been trying to refuse to give receipts. Like they pay with drop boxes, and they'll be like, oh, that kind of thing, and say we just don't do that, or oh, they got kicked out of the portal, so too bad kind of thing. Who knows? Always pay in a verifiable way, a way that you can prove. So if you don't get a receipt, pay in, a money order, certified check, personal check, even something like that. I see a hand. I promise I'm going to get to the chat questions. I just am reading and talking at the same time, but
We love that.
Chris.
Audrey, take a look at page 13 and other pages of the Montgomery County landlord tenant handbook. It says that landlords are required to give written receipts upon receipt of rents. So this business about going paperless, it's fine for them, but they still owe the tenant a paper receipt.
And
Yes.
if you don't get that, you can contact us as an intermediary and say, we'll call them and say, hey, but if it gets more formal, we would recommend that you file a complaint with the Office of Landlord and Tenant Affairs.
Right.
Yes.
And make it more formal, and hopefully it won't get anywhere near Audrey Lynn Martin in the courts, because they really have to do it. And I know that the Office of Landlord and Tenant Affairs takes a dim view of fundamental abuse of a basic law.
Yes, and I appreciate you clarifying that it is illegal to refuse. We still see it though. I was on the phone with a property manager. My tenant was standing in front of the building, the rental office, and they would not let her in the building with her rental assistance check from the county.
We passed a law last year specifically addressing that it used to be, it had to be a check or money order from the tenant, that a third party was actually not protected in law, but we changed that law so that a third party could actually pay the rent, which was certainly the spirit of the law in the first place, but was a loophole. But now they can't refuse to do that. We had a tenant recently who had all that check. The landlord refused to accept the check. He went to court with the check, and the judge had no patience with the landlord who wouldn't take it. So that's the way it works.
Well, I appreciate you, Pat. I didn't know that law was you. I cited it in my motion with that landlord. So
It was our board member, Delegate Vaughn Stewart, who led that charge, and we're very proud of him. And Delegate Janelle Wilkins, also another champion who's on our board, have been fighting for these kinds of protections all along. But as everybody knows, renter protections and law is slow going. What else do we have?
I am looking in the chat for other questions. I see. How about if I pay every month rent and sent you a letter from the court and said you're late from rent? How about I pay every month rent and sent you letter from the court, said you're late from rent? So I'm hearing that your landlord is saying that you're late and you're not actually late is what I'm hearing. I hear that every single week in court. I talked to a group of tenants from the same property, and this was, I think, like the fourth time all 4 or 5 of them have been brought in by their landlord for rent that they paid. And they ask, what can I do about this? And most of the time, individually, my answer is nothing. Landlords are allowed to waste your time. And I apologize for, I shouldn't have to apologize to y'all. Normally I have to be more unbiased in things, and I'm like, oh, I'm sorry. I'm a
This is the
tenant
Renters
advocate.
Alliance Town Hall.
I realize
When you're
that.
on the other guys, you can.
I have the right audience. I have the right audience tonight. Yeah.
Right.
Yeah. So yeah. Most of the time I say there's not much you can do. I told this group together, I was like, since it's happened to all of you together, you're all standing here talking to me right now. I said, all of you go together and talk to landlord tenant affairs about frivolous lawsuits. I was like, one of you going in may not do anything. Maybe all of you will.
Mhm.
I don't know if that'll do anything. We'll see.
Having a paper trail and having people stand up is important in public policy. It takes a long time. There's no silver bullet, but that's what we've been doing. And we're making slow but certain progress. So a pay and stay question, Audrey, in the chat says, if I pay down what I owe on the piece of paper, can I still be evicted? I imagine most of the time, no, sometimes yes.
Yeah, I appreciate you going through the chat. If one of y'all can give me the questions, because I've been trying to go through over here.
Yeah, well, that's what we got our people for.
Perfect.
and
I
me
will
too.
close
Go
the
for it.
chat and focus on answering the questions then. So the question was pay to stay, right
If
of
I
redemption.
paid down what I owed on the yellow piece of paper, can they still evict me?
The answer is no. So you have the right to pay the amount that the judge determined was due and owing. And if you got your paperwork stamped, it's written on the bottom, and the judge hand wrote that number in there. If you pay that amount anytime before the sheriff is at your door, or even when the sheriff is at your door, you have a check in your hand and the sheriff is at your door, the sheriff will watch you hand that check to your landlord, and they'll go on to the next person on their list. So yes, if you pay that amount, you can stay.
Except under one circumstance. And that,
Oh yes, unless, thank you. Unless you have had 3 judgments in the past 12 months and the landlord asked for the right of redemption to be closed on the last judgment.
So let's be clear about that. It's not in the last year. It's in the last 12 months. And
Yes.
3 judgments against you, not going to court 3 times, but actually if you went to court, you paid it down, the case was dismissed, that's not a judgment against you. But if the judge makes a judgment, it says, you were behind in your rent and you either pay it or you're going to be evicted, that's a judgment against you. 3 in the last 12 months. And as Audrey Lynn Martin says, if the landlord says, I've had it, I'm going to foreclose the right of redemption, your right to pay and stay, that could happen. Unfortunately, we hope that's extremely rare.
Yes. But we are seeing a lot more people reaching that 3 judgment rule, that like 3 strikes you're out kind of idea. We're seeing that now because a lot of judgments were entered last fall, so we're seeing those catching up now. But the window is often tight on those. So if you can get a continuance, a postponement on that 3rd one to get you out of that 12-month window. So if it was August of last year instead of September, and you can get that postponed out. That's one strategy to try to keep that right of redemption from being foreclosed. Also, it's important to note that landlords are not allowed to intentionally file separately to create, to falsely close the right of redemption. So you see landlords filing, oh, they didn't pay 3 months. And instead of filing one case for 3 months, they'll file 3 cases for 1 month and try to close it there. That is not
Right.
allowed. So they are not allowed to play that game. It can be difficult to prove if, they can say it was an honest thing. That's the way that they do the regular course of business. They do it 1 month at a time. But with the right judge and, the right passion of making that argument, you can, even if they get that judgment, you can say that the right of redemption doesn't need to be foreclosed because, it wasn't, good faith.
David, what else we got?
Well, I just want to acknowledge the questions I'm seeing about rent increases, what to do about those, and what to do when your lease is not being renewed. We got a little overlap on a couple questions there. But just to stay in this vein for a moment, I did see some about my case was dismissed. What do I do with, as far as my caseworker goes for rent relief? And, I got same question. I got a judgment, what should I do? I'm going to paste in, I did tell one person their DHHS has someone there, usually at the court, who you can tell, but I'm going to paste in the email that you can update them about whatever happened in your case with. But I don't know if you had any comments about what to do with that at that point too.
Well,
Yes.
and let's separate out the COVID rent relief questions and the landlord tenant questions for Ulta, which I'll try to run through. Is there anything else for you guys that we see specifically for our lawyer on our call?
Well, and I can talk briefly about the court timeline. I realized I didn't hit that with the failure to pay rent court. So you get your yellow sheet, you get a court summons, you come to court, and you have your court date. It's on a Wednesday or a Friday. And say you get a judgment that day, you walk in front of the judge, they ask the landlord how much is due and owing. The landlord will say how much they claim is due. They may say for $4,000 for February through April, or whatever. And then the judge will ask you, do you owe this rent? If the answer is yes, you will get a judgment. You can ask for the judge to stamp your paperwork, and that stamp will help you with your rental assistance application. So we encourage everybody who goes to court, who gets a judgment, to get it stamped. And this is kind of our way of getting you a copy of your order faster. So before, you had to wait until it went from the judge to the clerk, who signed it and then digitized it and then walked it downstairs to the downstairs clerk's office, who filed it, and then you had to go in there and ask the clerk for a copy of your order. And that was way too complicated. And so we asked, we're all here, can we do this a little faster? So the judge, instead of having to do all of that, will just stamp it right there, and that is an official order signed by the judge. So you're going to want to take that and add it to your rental assistance application. If you already have a caseworker, you can just email that directly to your caseworker, or we have people typically in the courthouse, just a couple rooms down from the courtroom, and you can add it to your application right there. I see, what if my paperwork isn't stamped? It's okay. You can also go back to the courthouse and go to the second floor and go to the landlord tenant clerk, give your name or your case number. If you don't know your case number, you can still just give your name. They can probably find it, and ask for a copy of your order. So just doing it the old way, and still getting that into your COVID rent relief caseworker, so that way you can get bumped up in the priority.
Audrey, I don't know if this is in your expertise. A question in the chat, which I have some experience with, where a tenant is now being charged utilities. And as you mentioned before, utilities are not rent, they're a separate fee. But now they're being charged utilities, but they're not sure how the utilities are being calculated. So there are
Mhm.
certain rights to demand that information. I believe in Montgomery County, if you request it in writing, they have 30 days to respond in writing to explain the bill. And if they don't, then you can file with the Office of Landlord and Tenant Affairs. In my case, and with Chris Perry, our vice chair of our board sitting there, we had that happen to us a few years ago. We asked to see the last year's worth of utility water billing, which they showed us. And then all of a sudden the water bills spiked up. And we said, well, what happened here? And they said they didn't have to show us. And we said, you do have to show us. Anyway, we filed in with landlord tenant and worked out back and forth with their lawyer, who finally agreed that to show us the information, but refused to sign an agreement to do so. So I stopped paying my water bill until the dispute was resolved, and they decided to retaliate against me by putting me on month to month. By the way, we all owe my landlord a great debt of gratitude for every advance we've made in renters' rights in Montgomery County. But anyway, so we refused.
Mine too.
And, yeah, right. And anyway, we went to court, and they, I'm not allowed to say what the settlement says, but it makes me smile every time. So that is what I understand. You are entitled to know that there are two formulas for water billing. One is the ratio utility billing system, if you're not individually metered. So it could be that the percentage that the apartment building has to pay, usually 25 to 35%. That's for the grounds, the common bathroom, the pool, and then the rest is divided amongst the people who live in the building, usually the people who are on the lease. That's one way. The other is square footage. They can determine the size of your apartment, and that's the square footage. Either formula, they have to, I believe, report to the Office of Landlord and Tenant Affairs or to the state. I'm not sure which, and then stick by that formula. And if you feel that that formula is somehow not being adhered to, then you have a right to find out what's going on and to make a complaint. Audrey, does that sound anywhere near what you understand?
You hit the nail on the head. It sounds like you know it far more in and out than I do.
Because I experienced it.
Yes, I know it from a very theoretical standpoint. Yes. And I saw another question about timeline. I keep trying to get on the timeline and I always get distracted. So you have your yellow sheet, you go to court. You probably get your yellow sheet. It varies as to when you get the yellow sheet and when your actual court date is. You know, it's just how backed up the court scheduling is. That is entirely determined on the court clerk and how ahead of time they are. It's normally a few weeks. So you're gonna have a few weeks notice that you're gonna have to go to court. Once you get your judgment entered for failure to pay rent, that is when the eviction ball starts rolling. So as soon as that judge stamps your paperwork, you are in the process of eviction. Before that point, things aren't really rolling yet. So you get the judgment, then your landlord has to come back to court 4 days later. No earlier than 4 days later, I should say, and request a writ of restitution, saying that is the paper that they can take to the sheriff's office to actually schedule the eviction. So after court, your landlord has 4 days, and then after that, they can get another paper. And then with that paper, then it goes to the sheriff. So after court, we advise people it can be about a month, but until sheriff actually comes or until you get a sheriff's notice. It varies because that also is entirely dependent on the sheriff's scheduling. But you will know when you get a red and white notice from the sheriff's office. So it is a white, smaller than a regular sheet of paper, maybe about this big, and it'll be on your door, and it has red words on it, and it says sheriff's office across the top. That is when you know things are, very, very dire. That is when the sheriff is going to come within, right now, I think it's about 10 to 14 days. and you don't know exactly when the sheriff will come. So maybe 1 to 3 months from the time you get your initial yellow paper to when you go to court. And then after court to when the sheriff, maybe another month. So it's a quick process.
If I can just tack on to that, when that red and white notice comes, that housing stabilization email I pasted in, there we go. Please, whether or not you have a pending COVID rent relief application, let housing stabilization know. There's a range of emergency programs that would kick in at that point, and they need to know. And like Audrey's saying, that means that it is dire there. And then I saw a question about someone was X number of months behind and hadn't received the yellow notice yet. So at the front end of that whole timeline, let's remember that landlords have a lot of discretion and they just move at their own paces. And some will, file, like we're seeing one comment I saw every month, there's a new summons. Okay. And then some like clockwork, but then some will wait a long time. So it is a lot of discretion there.
Yes. A lot of discretion, and if you want to get ahead of it, if you do think that, you have this balance and it just keeps building and it's going to become a problem, you can negotiate with your landlord, and you can reach out to an attorney can help you negotiate. I don't know if Renters Alliance will help you negotiate down. To potentially create a payment plan to prevent your landlord from ever filing an action against you. So there's a lot of discretion, as David said.
We can certainly help and counsel that, and we've helped negotiate before. But again, I say to tenants, your landlord is not your friend unless they are your friend or your mom or something. But if generally speaking, they are someone you're in business with. If you went to a restaurant and you ordered a steak and you got hot dogs, if you pay for the steak and walk out, well, I don't know what you're thinking. But for me, I'd say, hey, you can't do that, or there's some issue here. If you owe money to your landlord and you're worried about them coming after you with a court notice, speak with them. Go down and have a conversation with them and say, hey, look, I'm in this issue. I've lost my job, whatever it is. I'm behind. I want to act in good faith. How can we work this out? Just remember that whatever agreements you come up with, let's try to put it in writing, whether it's a follow-up email or something that says, thanks for agreeing to this payment plan or whatever it is. That you negotiate. And the same thing goes with some of these rent increases. Just because they say you owe 20 or 30% more in rent doesn't mean you can't attempt to negotiate it down.
Audrey, we go back to what we're running into is property management not offering leases. And just maybe you or Matt can remind me, do they need to give you 90 days notice if they're not going to offer you a lease?
60
days notice. And
Yes.
if they don't give you that 60-day notice, what can a tenant do?
So a tenant can talk to me is one. So if they give you the notice of non-renewal, mostly at that point, the tenant would probably want to wait and see if the landlord is going to file a tenant holding over action because
Okay.
they haven't renewed, or it's potential that they've just gone month to month. So if the landlord doesn't file a tenant holding over, it's just assumed that the tenant is month to month now and does not have a current lease.
Which we don't encourage.
Yes.
Right.
So I wouldn't. Yeah, I wouldn't rock the boat, but then they are in this unstable situation, which is a strategy that a lot of landlords do. So they will only give a 1 month lease and then go month to month, or a 1 year lease and then go month to month after that. And then be like, okay, well, then I have less requirements, as being a month to month as opposed to
And each month they could give you 60 days notice that they're going to terminate the lease, which gives them a lot more flexibility. We've seen that with landlords who view some tenants as potentially unstable because suddenly they were behind in their rent and maybe they're catching up. So they want to have the option of giving them a 60-day notice. Others have just decided not to renew leases. If you do not receive, we're in somewhat dispute with landlord and tenant on this issue, but they can only raise your rent once in a 12-month period. However, if the only thing that happens is the raising of the rent, then the landlord tenant office says that's not a renewal, it's just the raising of the rent. We disagree, but we haven't had that fight in court yet. But if you do receive a renewal notice, which has certain language in it, like welcome back, glad you're going to be here for another 2 months or 3 months, or continue on as our tenancy, and we're offering you a 2-month lease, a 6-month lease, and so on. That renewal notice has to contain certain legal elements in Montgomery County, including your current rent, the increased rent, the percentage of your increased rent, the county's voluntary rent increase guidelines. It has to offer you a 2-year lease and has to give you information on how to contact the Office of Landlord and Tenant Affairs in the event that you are in dispute over what they're offering you. So if it doesn't have those things, it's defective. And then what happens, Audrey?
Well, I have made the argument before. Well, if the notice for non-renewal is defective in a tenant holding over action, they'll dismiss it. But I have argued that the notice of non-renewal. So I had a landlord that just didn't send a notice before the 60 days were up, or it was not timely before the 60 days, and it didn't convert to a month-to-month lease. And my position was that they missed the opportunity for this to be able to convert to a month-to-month lease, because their only option at this point is to offer a 2-year because they didn't do the non-renewal. There was a very complicated argument. It was creative, they thought, but ultimately unsuccessful. We're going to keep fighting it, but there is definitely some wiggle room in that some legal nooks and crannies we can try to push open. I saw a
I want
question
to
in the-
emphasize,
Go ahead.
sorry, I just want to emphasize one thing. Audrey Lynn Martin is an attorney who works in the court. The Renters Alliance hopes that we can work with you well before you get to court. Dealing with these things early is very important. There's a whole Office of Landlord and Tenant Affairs, code enforcement that can help adjudicate and enforce to some degree the existing laws before you even get into a dispute that has to end up in court. So please be thinking about handling issues early before we have to essentially bring in the doctor in the emergency room, which is when we finally have to get to court. So keep that in mind. Sorry, Audrey.
No, I just pulled open the Q&A chat. I'm not on top of the questions, so if anybody sees any lawyery questions, let me know. But I saw one about childcare. So a lot of people bring their children to court. People understand, the judges, some of the judges are understanding of that. They may make you wait out in the hall, but if you check in with the bailiff, the bailiffs will typically allow you to stay out in the hall with your children if they're young or antsy, don't sit very well for 3 hours in a courtroom, like who does. I'm normally there. I normally have stickers for them. So there's no childcare, but you can bring your kids.
Here's something to really test your detailed knowledge of the law, Audrey, because I deal with this a lot, but this is not something that probably lands on your desk too often. Towing. We are seeing, of course, a lot of predatory towing, and over the years, there has been some additional protections. But we see apartment complexes that have a standing rule of, if you park here and your tags are expired or whatever, they can tow you. But we understand there are certain rules about towing nowadays. And one of them is that a demand has to be made, a request to tow has to be made in writing by the property owner or anybody demanding a tow, unless it's the police department. Are you familiar with that?
I am not familiar with that. I know nothing about towing. Yes,
Well,
that's a new one for me.
And again, I'm not a lawyer. I just play one on TV, but
Oh, no.
the Office of Consumer Affairs in Montgomery County handles this. The tow truck driver cannot be the sole arbiter of who to tow whenever they want. Used to be that they could even have a spotter. They called somebody who was looking around to find somebody to tow, or that if you were parked in the property and even walked off the property as the sign says you're not allowed to do that, it's not the tow truck driver who can be that arbiter. The owner of the property has to say this car can't be here, and they have to send a form that says that they request the tow. Absent that, it's considered predatory towing, and at a minimum, you should get your tow fee back. And at a maximum, you could get, I believe, treble damages for that tow. And I think we're going to have a renter town hall on towing alone one of these days, because it certainly is happening, and it is a terrible thing when it happens to you, as it's happened to me. It seems I've run into all of these problems.
I see another question in the chat. Can
yeah.
rent increases be discriminatory? Yes. So retaliatory eviction is something I didn't talk about. Retaliatory eviction can be a lot more things. It sounds like it just has to be an eviction. You have to actually get kicked out. It can be rent increases as well. And so if you think something has happened in retaliation or in discrimination, so retaliation for raising your rights as a renter. So if you filed a complaint with landlord tenant affairs, if you complain to your landlord, even verbally, which it's difficult to prove, but if it was verbally, but especially if you did it in writing, if you complained to your landlord, said, hey, my air conditioning hasn't been working, my water has been shut off for the past 3 days. And they follow up by either raising your rent, threatening to kick you out, not renewing your lease, actually kicking you out, bringing actions. They cannot bring things in retaliation or for discriminatory reasons. So if it's for any protected class, your typical race, gender, ethnicity, national origin, all of those. Disability. So retaliation and discrimination are big ones. And if you can prove those have happened, those are also treble damages. So 3 times rent.
And we love it when you can prove it. So always, if for anybody who's ever watched Judge Judy, you go to court, make sure you have photographs, emails, whatever it is that a common sense person would say, yeah, that's evidence of retaliation. Okay, witnesses. This one comes up all the time about if you're behind in your rent and you receive COVID rent relief, are you still responsible for your utilities? Yes, you are. But there is assistance out there for that. So we will put that in the chat, but there is state assistance and there is county assistance. So there's no reason to get in a situation of breach of lease, as Audrey mentioned before, for failure to pay your utilities when there is relief out there for this. And in our next newsletter, I mistakenly forgot to put in that information in our newsletter a couple of days ago, but we will put that out from the state. And Delegate Lorig Charkoudian from District 20 was one of the champions in strengthening that support for renters. What else do we have, staff? And Audrey,
I will also, sorry, I keep interrupting. I'll also mention that what you just said reminded me that these rent courts, these eviction courts are courts of injunction, injunctive relief. So they are not asking for the money. They are asking for the property. So that is another thing. That's another question I commonly get from tenants. Does this mean like the judge said I owe $4,000? Like, when do I have to pay? I mean, the answer is you have to pay if you want to stay there, but it's not a civil lawsuit unless they personally served you, which very rarely happens in the failure to pay rent court. That the landlord actually requests personal service. They have to go through extra steps and like pay somebody to do that, so they don't like doing it. That's the only way to ask for money damages. So it's important to note, if you have a judgment against you for failure to pay rent, you have been sued for the apartment, not for the money.
However, they could still come after that money. Go.
Yes. So you are sued for the apartment. So they are asking for the apartment back. So say the entire eviction goes through, sheriff comes, you turn over the property, you still owe this money, and the landlord can sue you, but they will have to sue you separately in another lawsuit. So you will be put on notice, you will have a summons, you'll come back to court. they'll present their ledger and show that you owe this money. But also, if it's a low amount, it's important to also remember that these landlords are paying private attorneys most of the time. If you are leaving a $1,000 balance, maybe they will pay an attorney that cost them $300 an hour to pursue that. Maybe they won't. And so those are choices that you have to make on where to spend your money, especially if you're struggling with housing insecurity. If you're already leaving the property, you may have more time to pay that debt you owe. That may be more just of a debt that you carry. But if you have to use that money to find a new place, you don't have a judgment for the money is an important thing to know.
And related to that, let me just answer a quick question here. If you are applied for COVID rent relief and you leave before you receive it, you will not get the COVID rent relief. The COVID rent relief is there to have you stay in your apartment. If you leave and you owe $6,000 and you qualified for the COVID rent relief, you're not going to get the COVID rent relief, and the landlord's likely to go after you for that $6,000. So keep that in mind. Very important. We'll put the COVID rent relief program, which still has millions of dollars available for renters who are behind in their rent because they were impacted by COVID-19. And there's other money available for other types of relief, but the COVID rent relief program is still open. And if you've lost your job or someone who is the person paying the rent in your household lost their job or was reduced in hours because of the pandemic, and you're more than 2 months behind in your rent, you can still get relief to pay that down. So please do that. It takes a long time. So hold on to your shoulders. It's going to take a long time. But if you are, they are prioritizing those who unfortunately are escalating towards eviction. So if they have a court summons, a court judgment against you, or God forbid, a sheriff's red and white on your door, they will prioritize your application and hopefully get you some relief. So keep that in mind. Staff, what else we got?
Good.
Everybody satisfied?
Questions that venture into landlord tenant very much is I'm kind of aggregating those.
All right. Well, if that is it for Audrey Lynn Martin, who was here 45 minutes more than we asked her to stay to answer all of these important questions, we are very grateful for your expertise and for your service to this very vulnerable community, especially vulnerable now. We look forward to working with you more. And we thank you very much for being here.
It's a pleasure to be here. I appreciate y'all having me. If you have my contact information, hopefully, I put it up there long enough. Otherwise, you can find me at court.
On
I'll be there.
Wednesdays. There's
On
an
Wednesdays
anteroom.
and Fridays, 4th floor. We alternate, but I don't tend to alternate. I'm just there every week.
Audrey Lynn
And
Martin,
support
homeless
rent
persons.
stabilization, support good cause. And thank you all for having me.
You betcha. Audrey Lynn Martin, Homeless Persons Representation Project Staff Attorney. Thank you.
All right, thank y'all.
See you. All right, let me move now to some information about the Office of Landlord and Tenant Affairs. That office is a county office. They handle disputes between landlords and tenants that have to do with your lease or promised or required services. So if you have a complaint in that regard, we ask you first to, if you need some information about what your rights are, whatever, we can certainly answer those questions before you file a complaint. But if it looks like something where you have a case, we would recommend that you file with the Office of Landlord and Tenant Affairs at Ulta Intake. Ulta, I think it's ulta.intake@montgomerycountymd.org. We'll put that in the chat for everybody. If you have a maintenance problem, you've requested in good faith, as with all of these things, you have a complaint in your apartment building, you go to the property manager, the landlord, and say, hey, look, this is not what you promised me, or the services are not being delivered the way they're supposed to. I'm paying for these things, or my refrigerator is broken. You go to the landlord or property manager and you say, this is the problem. And within a reasonable period of time, they should respond. If they do not respond, especially after a few days, ping them one more time. But if they don't respond, there's no reason why you should pay for broken appliances or services that you're not getting. Air conditioning, stove, refrigerator, if there is mold and vermin in your apartment, if your carpet is so worn that it becomes a tripping hazard, if there's a broken window or your front door is broken, these are required by code, by building code in Montgomery County and in the state of Maryland. And so we have a complaint process for the Code Enforcement Department of Montgomery County. And if we could get that also, that complaint in the chat. Again, we can be a buffer before you get down that road and help explain to you when it's time to really make a complaint, when it's time to what the issue might be. There are some justifications for a landlord taking their time. Sometimes they're waiting for a part that is not available to them. Sometimes, they have short staff or whatever. I tend to think that, there's a certain amount of time, once, twice, thrice, otherwise deliver it to me or lower my rent, one or the other. So we do like to see these things taken care of. The Renters Alliance was behind a legislation that passed in 2016 that allows that if you file a complaint with the Code Enforcement Department and they agree with you and cite the landlord to say, fix your toilet or fix a dripping faucet, and they do not do it, then if with permission from the Office of Landlord and Tenant Affairs in writing, you can fix it yourself, provided the amount of the cost to repair is not more than 1 month's rent, and then you can deduct it from the rent. But just make sure that you do all of this under the written oversight of the Code Enforcement Department of Montgomery County. What else? Like I said, are we allowed management to clean carpet after a certain amount of time of living in the same unit? Allow management if you can get them to do it. I think that's great. I think otherwise you'll have to do it yourself. Carpets are not really protected the way some other things are. If it becomes a tripping hazard, is the standard I understand, then code will cite them to fix it. If it's a tripping hazard because you have damaged the carpet, then you will be responsible for it. So if you drag something across the carpet and you cut it and it's sticking up and creates a tripping hazard, then first of all, it's a code violation that has to be repaired, but you will be responsible for paying for it. If it's a tripping hazard because of normal wear and tear, you've been in the apartment for 15 years and it's finally worn through and sticking up, well, then the landlord's going to have to pay for it. That's my understanding. But you are also entitled to have your apartment painted every 5 years if you request it. So that is also something to keep in mind. No, there is no law that says a carpet has to be replaced every 5 years. Some carpets last long time. Other carpets do not. So it depends. So what I just outlined is all I know about carpets, except flying carpets. Okay. What else?
We can go back to Ulta for a minute. There were a lot of questions earlier on about rent increases, specifically about whether over a certain amount, if there's anything someone can do. Did you want to lay out who you think they should let know and what they get?
Go ahead, David. You know what I'm going to say.
Well, yeah, I mean, let us know for sure. The info Renters Alliance there. If you think it's unreasonable or out of the blue, or especially then if you think it's retaliatory or discriminatory in some way. But then, yeah, the ulta.intake would be the section of the county, and they actively want to know about it too. And then it is tied to what Matt said earlier about the pending legislation. The more they know about these things, the more the council becomes aware too, hopefully. And so that's who we recommend you let know. But then, yeah, but there's not a certain point where it becomes what's called a constructive eviction, right? That if it's so egregious that it's a constructive eviction, then there is action I think the county can take.
Well, we'd like to believe so. We certainly think we have some conflicting history here. The county Office of Landlord and Tenant Affairs has in the past taken the position that an excessive rent increase that to any reasonable person says it's so high that if I have to pay it, I have to leave. Then that could be considered what they call a constructive eviction, that is taking some action against you that effectively evicts you without actually evicting you through the courts, like raising your rent, to such a level that no reasonable person could pay that. However, of late, the county has not taken the position that they would enforce that. We think they should. They haven't done so yet. We're all citizens. We hope that we raise these issues to the county and get them to strengthen those laws and strengthen the procedures to defend against them. The county is, however, under the leadership of the county executive, Mark Elrich, who's very concerned about excessive rent increases that we are seeing. They are collecting examples of excessive rent increases. I would say anything over 4.4% is excessive, especially those rent increases in the double digits. They have received upwards of 90 complaints with an average increase of 21% so far. And we believe that's the tip of the iceberg. Let's show them the iceberg if you have examples. So send those in, as David said, to ulta.intake@montgomerycountymd.gov. Now, also keep in mind, you should try to get it down. I used to get rent increases when I first moved here of 10%, and I would negotiate with them to get it down to something more reasonable. Give it a try and see what can be done. I'd like to believe that a responsible landlord, if you have children, if you're a senior citizen, if you're struggling with your work because of whatever reason, that they would try to be decent with you and negotiate something. I'd like to believe a responsible landlord would do that. Some of them are not responsible. Some of them are entirely based on whatever they think the market will bear and believe they have no responsibility for community stability and your stability. So that is unfortunately what our challenge is right now. What else do we have, folks?
And so feel free to CC us on any of those communications when you're trying to say that sort of thing too.
Thank you.
And then just to tack on quickly, this might be a good time to mention that if you live in the city limits of Rockville or Gaithersburg or Tacoma Park, they have their own Ulta there that you can contact. And then also I see a question here about if you're not satisfied with the Ulta outcome, then there is a COLTA. There's a commission on landlord tenant affairs and also that can review these things as well. So there are, steps of review beyond that. So I just be aware of that. Thanks.
Yeah, thanks, David. Let me just underscore that point. If you live in the city of Tacoma Park or the city of Gaithersburg or the city of Rockville, did I miss one? Gaithersburg, Rockville, Tacoma Park. You are not under the jurisdiction of Montgomery County Landlord Tenant Affairs. You have to work through those local municipality jurisdictions. For the most part, they have the same laws for the most part, but not entirely. For example, they did not have the rent stabilization law that was put in place by Montgomery County. Some of them had it for a shorter period of time, may not have been the same percentage, so they don't have that. Some of them do not have the same level of code enforcement operations that the county has. So just keep in mind that there are 3 municipalities, Gaithersburg, Rockville, and Tacoma Park, that have their own housing departments, and then there's Montgomery County. Montgomery County law does not supersede the municipality's law in housing. However, state law does. So if there's a state law in place, then all the counties and all of the counties have to abide by that. So, and we know something about that, and we can direct you through that. Malek or Pat or Chris, is there anything we're missing that's also in the Q&A or in the chat?
I think we just have one, which we're not lawyers. But if a tenant has a hostile environment in their apartment building and property management has not addressed it, what is our recommendation?
Well, of course, it's an always it depends kind of situation.
Yep.
There's hostile, once in a while. I mean, I've lived in my building 20 years. Every now and then you bump into somebody you don't like, somebody who's difficult. Okay. You know, we all live in a neighborhood. And that's, we say building community, and sometimes that community has people who disagree. Then there are things that become what they call threats to your quiet enjoyment of your apartment. If you have somebody harassing you in a serious way, banging on your door, threatening you, you first, you know, unless you feel that your life is in danger, you should call the police. If you are just being harassed and made to feel uncomfortable, you should report it to the property management. And there are legal options there. Again, we're not lawyers, but you could seek a restraining order of some sort through the courts and get legal advice on something like that. Common kinds of things that bother people are like an apartment that, in a smoke-free environment that has smoke billowing out of the underside of its door. Well, you know, you should complain to property management, and you should also get evidence and make sure that the evidence is in writing. Property management is responsible for assuring what it is that you're paying for. And if it's a smoke-free environment, then you might have a case, but you're going to have to prove it. If you have someone in the building who's constantly providing excessive noise, you know, the first neighborly thing to do, unless it's a once in a while party for a graduation or something, but if it's a regular problem, you need to knock on the door and say, hey, you know, you're bothering me, and see if you can work it out. If they refuse to work it out, you need to report it to the property management, record it, make sure that you have evidence. And if the property management does not act to deal with it, that is what the Office of Landlord and Tenant Affairs is set up to adjudicate. And so with your evidence, with your proof that you informed the property management and they refuse to do anything about it, you can file a complaint with the Office of Landlord and Tenant Affairs and get them to do something. And if the noise is really loud, especially at 2, 3, 4 o'clock in the morning, call the police so that you can get a police report to accompany your complaint if necessary down the road. I think that's sort of what I would say to that. All right, well, it's 8:27. We will look
Pat,
at,
Excuse
go
me,
ahead,
Matt.
Pat.
Well,
Yeah.
we have one renter. I think this is an important question for a lot of renters. And it's about what resources, if the landlord does not want to renew your lease, and refuses to mediate, what would be, I guess, Renters Alliance
There's an unfortunate reality. The first
Okay.
reality is that there is no just cause eviction law in the state of Maryland,
Right.
something we're fighting for. Just cause eviction law would require that the landlord state a justifiable reason not to renew your lease.
right?
Right now, there is no law that protects you from that. As long as they give you 60 days notice, they can decide not to renew your lease at the end of your lease.
Good.
Now, defense against that is if you believe they're retaliating against you for pursuing promised or required services, organizing a tenants association, or for something that Audrey Lynn Martin said earlier, for discriminatory purposes. They're going after you because of the color of your skin, your religion, or some other protected class reason. Then you have a fight, but you do have to prove it, and that becomes particularly difficult. Since in court, they're not going to ask the landlord to say why. They're just going to want to know that the landlord gave 60 days notice. If the landlord does not renew your lease, it doesn't necessarily mean that unless they give you that notice, it doesn't mean that you can't stay there anymore. It just means that when your lease expires with no other notification, you will go month to month. And your lease is still in effect, except that its term is now month to month. Okay?
Good.
All right, 8:29. I know that there's probably more questions out there. We have these renter town halls twice a month. We will have another one, I believe, on the 28th of September. And so we invite you back. We will have the Office of Landlord and Tenant Affairs on as well. And as I say, Audrey Lynn Martin was able to join us this evening from the Homeless Persons Representation Project. Rosie McCrae Moody was filling in for Nicole Catravanos, who had a sick child, and then she had a fire alarm in her building. So we lost Rosie this evening. So that just wasn't going to happen. But we will get them back next time. And you can always email us your questions or concerns at info rentersalliance.org. We understand the challenges that are going on out there. We are all renters and we're with you. So with that, thank you and good night.
Good night.